Respected Professor Dr. Farid Sufyan bin Shoaib, Dean of Ahmad Ibrahim Kuliah of Laws IIUM, Respected Dato Haji Akbar bin Haji Samun, CEO of the Islamic Religious Council of the Federal Territories, MAWIB, the Learned Shari'ah Appeal Court Judges, JKSM, the Learned Shari'i Chief Judges of the State's Shari'ah Judiciary Departments and State's Shari'ah Courts, Respected Tuan Haji Nasir bin Haji Abdul Aziz, Chief Registrar, JKSM. Yang Amat Arif, Yang Arif, Dato, Datin, Professor Doctor, Honorable Guests, Participants, Ladies and Gentlemen, distinguished audience. My name is Syaiful Azli bin Jamaluddin, and it is my pleasure to be your Master of Ceremonies for this session. Welcome to the International Conference on Family Law, Family Justice, and MAQASID AL-SHARI'AH, ICFL 2021. This international conference is jointly organized by the Shari'ah Judiciary Department of Malaysia, JKSM, the International Islamic University Malaysia, IIUM, Islamic Religious Council of the Federal Territories, MAWIB, and the Malaysian Sharia Officers Association, PPSM. The main theme of ICFL 2021 is towards the sustainability of family institutions. This conference has gathered a number of experts and researchers in the fields of family law, family justice, and MAQASID AL-SHARI'AH. Many topics and issues will be discussed in detail by each presenter as the conference proceeds. We believe that the outcome of this conference will contribute immensely to the development of the Islamic family law and the Sharia law in Malaysia. Now, the Right Honorable Adjunct Professor Dato Setia Dr. Haji Muhammad Naim bin Haji Mokhtar. He is originally from Kampung Baru in the heart of Kuala Lumpur. He is married to Datin Nek Huslini binti Haji Raja Ismail and blessed with 3 kids. He graduated with LLB from the Ahmad Ibrahim Kuliah of Laws, IIUM, LLM from the University of London, United Kingdom, Diploma in Sharia Legal Practice, DSLP, and Diploma in Administration, Islamic Judiciary, DAEJ, IIUM. He completed his doctorate at the National University of Malaysia. He was appointed as the 4th Director General and the Sharia Chief Justice of the Sharia Judiciary Department of Malaysia, JKSM, on 1st April 2019. He is a very experienced figure in the legal service. Among his outstanding appointments include as an appeal Sharia Court Justice of JKSM, a Sharia Chief Justice of Selangor, and the Director of the Family Support Division of JKSM. He has also been elected to sit in some of the most important committees and decision makers on the legal policies nationally and internationally. Internationally, his legal expertise is recognized when he was on numerous occasions being selected as a Malaysian Sovereign Visiting Fellow at the Oxford Centre for Islamic Studies, University of Oxford, United Kingdom 2008-2009, and a visiting fellow at the Harvard Law School, University of Harvard, United States of America 2012 and 2013. Academically, his capability is distinguished with the conferment of adjunct professorship by the International Islamic University Malaysia, IIUM, University Technology Mara, UiTM, Islamic Science University of Malaysia, and recently by the University of Sultan Zainal Abidin. He has on numerous occasions been invited as a presenter and speaker at conferences inside and outside Malaysia. Socially, he is also active in giving talks and sharing thoughts through the mass media. He will be delivering the keynote speech coinciding the theme of ICFL 2021 itself on the history and development of Islamic family law in Malaysia. Without further ado, we respectfully invite the Right Honourable Adjunct Professor Dato Setia Dr. Haji Muhammad Naim bin Haji Mokhtar.
Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin wa bihi nasta'in. Wassalatu wassalam ala Sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. A'udzu billahi minasy syaithanir rajim. Ya ayyuhalladzina amanu athi'ullaha wa athi'ur rasul wa ulil amri minkum فإن تنازعتم في شيء فردوه إلى الله والرسول إن كنتم تؤمنون بالله واليوم الآخر ذلك خير وأحسن تأويلا. O believers, obey Allah and obey the Messenger, and those from among you who are invested with authority. And then, if you were to dispute among yourselves about anything, refer it to Allah and the Messenger, if you indeed believe in Allah and the last day. That is better and more commendable in the end. يا أيها الناس اتقوا ربكم الذي خلقكم من نفس واحدة وخلق منها زوجها وبث منهما رجالا كثيرا ونساء واتقوا الله الذي تساءلون به والأرحام إن الله كان عليكم رقيبا. O humanity, be mindful of your Lord, who created you from a single soul, and from it he created its mate, and through both he spread countless men and women. And be mindful of Allah, in whose name you appeal to one another, and honor family ties. Surely Allah is ever watchful over you. Surah An-Nisa verse 1. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Honorable Dato Dr. Muhammad Daud bin Bakar, President of International Islamic University Malaysia, IIUM. Honorable Professor Dr. Farid Sufyan bin Shuaib, Dean Ahmad Kulliyah of Laws, International Islamic University of Malaysia. Honorable Dato Haji Akbar bin Haji Samun, Chief Executive Officer, Federal Territory Islamic Religious Council, MAWIP. The Honorable Judges of the Shari'ah Court of Appeal, Department of Shari'ah Judiciary Malaysia. The Honorable Chief Syarie Judges of the State's Sharia Courts, Tuan Haji Nasir bin Haji Abdul Aziz, Chief Registrar, Department of Shariah Judiciary, Malaysia, my fellow academicians, Shariah officers, and respectable guests. First and foremost, I would like to welcome all the VIPs and guests to the International Conference of Family Law, Family Justice, and MAQASID AL-SHARI'AH. Thank you for being part of our conference. My deep appreciation goes for all for sharing your valuable thoughts and findings in our first ever international conference. Honorable audience, the first part of the verse that I read is from Surah An-Nisa, verse 59. It symbolizes that the formulation of law must be based on the Quran and Sunnah of the Prophet sallallahu alaihi wasallam. And obeying such law is every Muslim's obligation. The second verse is also quoted from the same surah, verse 1, narrating on the responsibility of Muslims to respect and guard family ties. I believe the two verses are the main contents of our conference today and tomorrow. As Muslims, we believe that the Sharia or Islamic law is a legitimate set of law, although some contended that the law conflicts with the core elements of free society, such as constitutional democracy and the rule of law. Malaysian legal system is a proof that such law is compatible with the basic needs of the human. We Muslims believe that Islam is more than just a religion. Its values penetrate every aspect of living. Here I see the relevance of the wise words of Imam Ghazali rahimahullah in his book Al-Iqtisad fil I'tiqad at page 128, when he says, Ad-dinu ussun was-sultanu harisun wama ussun lahu famahdumun wama la harisa lahu fadha'i'un. The deen is a foundation and the ruler is the guardian. What is without foundation is doomed to collapse, and what has no guardian is doomed to extinct. Respected learned audience, fitting the theme of this conference, I would like to talk on the Islamic family law and MAQASID AL-SHARI'AH. Islamic family law is compatible with basic needs of the humans. It outlines the rules that govern human-to-human relation, personal matters of the Muslims. The interesting aspect of this law is that it is founded on the commands of Allah subhanahu wa ta'ala, the Khaliq who created the humans. The Muslims believe that it is only right that the Creator stipulates rules on the created. Islam as a religion was found to have arrived in Tanah Melayu in as early as the 12th century. The first physical evidence of the influence of Islam was found in the state of Terengganu, where a set of writing in Arabic letters was found crafted on a rock called Batu Bersurat. The rock dated 22nd February 1303 AD. Looking back into the history of Islamic family law, one would find that the law is no alien to Tanah Melayu. Its implementation could be traced back to the glory days of the Malay Sultanate. Rather, it was not only the Islamic family law that was implemented back in those days, but the whole set of Islamic law was also used to regulate every civil, commercial, and criminal matters. One of the early legal texts which was found to implement Islamic law is the Undang-Undang Melaka or Hukum Kanun Melaka. The law was later widespread to other states. These states had to a certain extent based their laws on Undang-Undang Melaka. This was possible given the role of Melaka at that time as one of the important trade centers, which made it as a politically strong state. Studies on the early laws, including Undang-Undang Melaka, Undang-Undang Pahang, Undang-Undang Kedah, 99 Perak laws, and Sungai Ujung laws, found that there are similarities between these laws, particularly in terms of their content. The influence of Islam and Islamic law is enshrined in Undang-Undang Melaka. Careful examination on the law found that there are some Islamic legal terms used throughout Undang-Undang Melaka. The terms such as Bismillahirrahmanirrahim and Wallahu A'lam Bissawab were used as a beginning and closing of each chapter, fasal of each law. Islamic legal terms used include nikah, marriage, talaq, divorce, mudda'i, plaintiff, mudda'a alayh, defendant or accused, buy, sale, transaction, shahadah, witnesses, and ikrar, confession or admission. In respect of family law, the rules or hukum syara on family matters in Undang-Undang Melaka was directly based on Mazhab Syafi'i. Among the family law areas found in Undang-Undang Melaka were related to betrothal, Chapter 18, instituting a valid marriage, such as rules relating to consent to marry, guardianship of marriage or wali, Chapter 25, witnesses, Chapter 26, ijab and qabul, Section 25.2, and repudiation of marriage, Chapter 28. The provisions of Undang-Undang Melaka showed the direct adoption of Islamic rules in the law. One of such provisions is reproduced here. 28.1, fasal yang ke-28, pada menyatakan hukum talak. Adapun talak itu dua perkara. Pertama, talak bain namanya. Kedua, talak raj'i namanya. Adapun talak bain itu seperti talak yang tiada lagi akan kembali, iaitu seperti talak 3. Adapun talak raj'i itu seperti talak 1, atau talak dua, maka ia dapat kembali lagi. The translation is, talak or repudiation is of two types. The first is talak ba'in, irrevocable. The second is talak raj'i, revocable. The irrevocable repudiation of marriage is, for instance, a repudiation that cannot be withdrawn, such as the threefold repudiation. The revocable repudiation is a single repudiation or the twofold repudiation. That is, the husband may still return to his wife by simply remarrying her. It is observed that regardless of thousands of years difference, the application of basic rules regulating family law matters are somewhat similar to what we have in our family law today. This is the proof of uniformity of Islamic law, where the structure that holds the law does not change as the sources of law remain, namely the Quran, Sunnah, and juristic opinions. Respected ladies and gentlemen, the next phase of the application of Islamic law in Tanah Melayu, however, was not supportive for the development of the law. The British brought in the common law into the region and made it as the main law. The civil courts were presided over by English judges or judges who were of common law background. The Islamic law that was in practice before that was made subordinate. The functions were confined to only cater for the personal matters of the Muslims. As the Islamic law was under the jurisdiction of each state, the legislations were scattered and differently practiced. There were issues relating to ambiguity of the position and jurisdiction of the Sharia courts and the competency of the Sharia judges. This has contributed to inferiority of the courts. The civil courts reversed and overturned the decisions by the Sharia courts and decided it according to the common law principles instead. For example, the case of Ainan bin Mahmud versus Said Abu Bakar, 1939. The issue in the case relating to the status of a child born 4 months after the mother's marriage. The civil court decided the child to be legitimate despite the stipulation in the Hukum Syara that a child must be born at least 6 months after the marriage in order to assume the legitimacy status. And the Sharia court or the Qadi courts at that time have already made ruling as to the illegitimacy of the child, but the parties were not happy with the decisions of the Qadi courts. They filed a case, appeal in the civil court, and the civil court reversed the rulings and the decisions of the Sharia court or the Qadi courts. Another example is in the case of Re Maria Hartog, 1951, where decision by the Sharia court, which held the valid status of marriage of a Dutch lady to a Malay man, was overturned by the civil court, again based on the English law principle of domicile and eventually held the marriage as invalid. The interference remained until after the independence. In Martin versus Umi Kalsum 1963, a marriage that was decided to be invalid according to Hukum Syara was held to be valid by the civil court based on the English domicile principles. Development of Islamic family law. My dear audience, starting from after the independence, the Islamic law has been significantly developed. The efforts to compile and strengthen the Islamic law and clarify the position and jurisdiction of the Sharia courts were made. One of the most significant developments include the amendment to Article 121 of the Federal Constitution by inserting Clause 1A in 1988, which confirmed the exclusive jurisdiction of the Sharia court, and thus it is to remain exclusive and should not be interfered with. As for the Islamic family law, the law has undergone significant development in terms of its legislation and implementation. The provisions relating to Sharia law were formally compiled in one legislation. For example, in Selangor, the law was compiled in the Administration of Islamic Law of Selangor Enactment 1952. The provisions were brief and were only covered in few sections. Reforms to the Islamic family law took place between 1976 to 1980. The government took the effort of establishing the Technical Committee of Civil and Sharia Law, headed by our beloved Almarhum Tan Sri Professor Ahmad Ibrahim at that time. Thus, efforts to compile, expand, and detail the legislation began. The Islamic family law legislation passed in 1980s became the first version of Islamic family law that are enforced today. Though some states have amended their legislation, the basis of the first version of the law remains. Starting from the efforts of consolidating the law into one specific legislation, the development of the Islamic family law has been persistent and constant. The Islamic family law of Malaysia is recognized to be the most progressive set of Islamic law in the Muslim world. It is a comprehensive legislation that details on the aspects relating to marriage, divorce, custody, maintenance, and other familial disputes such as inheritance and legitimacy. As the law is considered as commandments from Allah subhanahu wa ta'ala, making sure that the disputes are decided accordingly, determine the validity of certain relationship, status, and or eligibility. Besides that, it also obliges one to carry out the outcome of disputes, not only as a decision by the court, but he also owes the amanah to carry out the outcome as an obligation of a Muslim. Now, I'm going to talk on MAQASID al-SHARI'AH in the administering family justice. My dear learned brothers and sisters, Islamic family law is a unique aspect of law, where different from the family law which is formulated on man's relevance and thoughts. The Islamic family law originates from the rules stipulated by Allah subhanahu wa ta'ala, and thus it becomes an obligation on each Muslim, not only as citizens who need to respect their rule of law, but it also symbolizes their obedience to the commands of Allah subhanahu wa ta'ala. Notwithstanding the fixed nature of legal rules derived from the Quran and Sunnah of the Prophet sallallahu alaihi wasallam, the law also comes with 5 basic objectives. The MAQASID al-SHARI'AH that place the important objectives of Islamic law are the 5 main considerations which need to be borne in mind whether in setting or implementing the law. The stipulated law and the MAQASID al-SHARI'AH create an equilibrium in the administration of justice in the Shari'ah law generally and Islamic family law specifically. The administration of justice in the Islamic family law, or termed as family justice, basically revolves around implementation of the law in resolving disputes between spouses, children, and family members. In the process of implementing the law, the rights of the parties have to be given proper consideration, and in cases where it involves the rights of children, their rights have to be given utmost consideration. This coincides the concept of justice in Islam, or adl. It is agreed that justice plays an integral part in the legal administration in Islam. Adl translates as putting things at its rightful place and giving everyone their due rights. As justice is considered as the central theme in Islam, it is observable in every Allah's commands to the Muslims, especially in matters relating to family disputes. Considering the importance of MAQASID al-SHARI'AH, especially in adjudicating Islamic family disputes, Department of Sharia Judiciary Malaysia, JKSM, has indulged into research to see the extent of the use of MAQASID al-SHARI'AH by the judges in deciding cases relating to the determination of the custody of the children, or known as hadana. The research found that in adjudicating such cases, the judge tends to put utmost consideration in protecting the welfare of the children. Objectives of protecting their religion, intellect, and lineage are carefully looked upon in order to decide for the betterment of the child's welfare. Thus, in some cases, the custody is placed with a family member whom the child is comfortable with emotionally, though the hukum syara might hold it otherwise. This can be illustrated in the case of Yusnidah binti Hussein versus Wurda binti Shamsuddin, which is unreported in 2015, pertaining to the custody of 2 children whose parents have died in a car accident in Duke Highway. The children have been taken care by their auntie, the plaintiff. Although the defendant, the grandmother, objected by referring to Section 81 of the Islamic Family Law Act relating to the hierarchy of family members entitled to child custody. The court, by considering the children's welfare and emotions, have decided that the plaintiff should get the custody. The judge in this case referred to juristic opinion of Ibn Qudama, who opined that Havana or custody of a child should be decided upon considering child's fate and interest. Now we move on to the issues and challenges in administration of Islamic family law in the 21st century. Ladies and gentlemen, brothers and sisters, the efforts of the Sharia law do not come without challenges. The challenge of 21st century that places each country in the international eye and thus subject them to critics and scrutiny. I would say that the bigger challenge is for the Muslim countries. Our Sharia legal system especially is on most occasions being questioned as it is deemed to be unequal with their standards of human rights. Nonetheless, as the federal agency, JKSM is committed to channel correct information in responding to the critics. In drafting our response, we realized that it is very important to spread accurate information in the most diplomatic way. This is to let the critics see that Islam is against any practice of injustice and that we are on constant effort to overcome the weaknesses, as what other agencies are currently doing. It is noticed that there are some recurrent issues that have become international concerns over the years. Among them, firstly, neglect of women's rights in dissolution of marriage cases. The critics on this issue are generally concerned with the abandonment of rights of women to have their issues and claims dissolved before the Sharia court. In previous years, there have been complaints against the Sharia judges being gender biased. Cases will also consume longer times to be dissolved. Some might take years. This has caused rights of women to be delayed. Though the critics were in most times subjected their comments to the incompetency of the Sharia judges, it was also found that the delays were also caused by failure to execute court orders. This was in most cases due to evasive attitude of former husbands who escaped their responsibilities by not upholding the court orders to pay maintenance. Eyeing to find solution to such problems, JKSM is proud of our own family support division known as BSK, which is established to ensure effective execution of such court orders. This division has been in operation for more than a decade in every Sharia court in the states, and many have benefited from it. In 2020, more than 70% of registered cases in each unit which include Unit of Legal Advisory and Unit of Enforcement and Execution of Judgments or orders have already been resolved. The operation of the Family Support Division includes providing temporary financial assistance in the form of advance payment of maintenance to the women and children to support their living expenses immediately after the divorce. The advance payment will be obtained from the defaulted ex-husbands or fathers who are now judgment debtors, and effective measures are used to make sure that they continue to carry out their responsibilities. In addition to that, with the advance of technology, the Family Support Division, BSK, has as well moved together with it. Electronic systems such as e-Nafakah or e-maintenance was established in 2012 with the aim to have a systematic tracking system of execution of maintenance orders in all the states in Malaysia. The system alerts any delay in the execution, and the division takes heed by reaching the evasive party and alerting them. With the target to solve problems relating to the delay of cases of maintenance, nafakah, and child custody, hadana, Mahkamah Syariah Wilayah Persekutuan or Syariah Court of the Federal Territory of Malaysia, bahagian nafkah dan hadanah was established in July 2018. This court division, which consists of High Court and lower courts, aim to shorten the period of resolution to 6 months. We believe that by having a specific division of court with specific function, the expertise of judges sitting in such court can be nurtured, and this will increase the possibility of having disputes resolved effectively in a shorter time. Another recurrent issue is with regard to underage marriage. The issue of underage marriage became a concern around 2018, though the practice has been happening before that, as the news of such marriage narrating on Malay Muslim girl of 11 years old who married a 41-year-old man, and a 15-year-old girl who married a 44-year-old man. The Sharia court received a backlash and being accused of allowing such practice in the society. I believe that my learned colleagues in this conference are well aware of the marriage requirement as stated in the Islamic family law legislation, where it specifies the minimum age of marriage of 16-year-old for women and 18 years old for men. Reference can be made to Section 8 of IFLA. As such, no marriage can be contracted under the stipulated age except with the leave or permission of a Sharia judge who decide the application to marry. Many call for the minimum age to be increased. JKSM did accept the suggestion. Nevertheless, some research also found that such marriage, which also occurred among the non-Muslim societies, are mostly due to the financial incapacity of the families by marrying off their daughters to men who can sustain their life would lighten their burden. That what the research has come out, the main factor why the existence of the minor marriage or underage marriage. I would like to state that we are not in any way agreeable to the practice of underage marriage, as it could cause injustice to underage girls, especially, and any form of injustice is prohibited in Islam. La darara wa la dirara fil Islam. One noticeable serious injustice is that it could cause health-related problems such as depression, sexual illness, cervical cancer infections, risk during pregnancy and childbirth, and risk to infants born by a child. Be that as it may, JKSM believes that it should take a proactive role in resolving the issue, at least from the Sharia legal point of view. Thus, in the same year, which is into 2018, JKSM has formulated a strict set of SOP to guide the courts in deciding cases of application to marry by underage parties. The particular SOP, Standard Operating Procedure, has been reported to an international rapporteur on the rights of women and children who came to Malaysia in 2018. The SOP has as well been translated into English and circulated to all the Sharia courts. Cooperation with the Social Welfare Department and the hospitals are also formed, as these agencies have the expertise to handle underage parties, socially and medically. So far, Alhamdulillah, JKSM has been following up with the courts to see their adherence to the Standard Operating Procedure. Ladies and gentlemen, brothers and sisters, another challenge that we are facing today is to reach out to the society in the middle of pandemic COVID-19. When MCO was first announced last year, in March 2018, we struggled to find the most effective way to reach out. As many of you might have come across reports stating that there had been increase in the number of family disputes, domestic violence during the pandemic, especially with regard to the divorce cases. We believe that we have the obligation to operate our courts so as to do justice to the parties. For that matter, SOP was developed, and Alhamdulillah, Sharia courts were one of the first to open its door to the public with strict adherence to the SOP. We have also ventured into online hearings and trials in order to further accommodate the public. We have as well organized series of talks with the aim to explain to the public about their legal rights and duties relating to family disputes. My dear learned audience, brothers and sisters, till today, we are still struggling in our journey to have an all-encompassing set of Islamic family law in the country. Research, continues to be carried out, and the outcome of this conference, inshallah, I believe, will contribute greatly to the advancement and development of Islamic family law in the country. Before us today are two categories of the learned participants, one who practice the law and the other one who research. I'm taking this opportunity to congratulate to all who will be presenting their research finding in this conference, the practitioners and academics, particularly for Sharia officers who made an effort to present their papers, their thoughts. I sincerely say to all of you that I'm very proud. Saya merasa bangga dengan usaha yang Arif, tuan-tuan dan puan-puan telah mengambil di dalam membentangkan pandangan dan pengalaman berkongsi dengan rakan-rakan yang lain dalam seminar seperti ini. My sincere wish is to see more officers to participate in this kind of a platform and be bold enough to share your experience with others. Let us all learn and share knowledge. The only way how we can together develop Islamic family law is by working hand in hand. وَتَعَاوَنُوا عَلَى الْبِرِّ وَالتَّقْوَى وَلَا تَعَاوَنُوا عَلَى الْإِثْمِ وَالْعُدْوَانِ. The combination of these two categories of good Muslims, those who are practicing and the one who are research, the academicians and the practitioners of law, I believe will be most certainly be blessed and rewarded by Allah subhanahu wa ta'ala. My deep appreciation is what I can bid to you all now. My dua is that your work and research will be accepted by the grace of Allah subhanahu wa ta'ala, and may all of you be immensely rewarded by our Creator, Allah subhanahu wa ta'ala. With that, I end my speech. Wabillahi taufiq wal hidayah. Wassalamu alaikum warahmatullahi ta'ala wabarakatuh.